Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Robert E. Temmerman Jr., and I'm just going to call him Bob. And Bob is an attorney, he's a partner in a law firm. It's Temmerman, Silly, and Coleman, LLP, in San Jose, one of the founding partners. That firm specializes in estate planning, incapacity planning, and estate and trust administration, and also they do litigation as well in the estate area. He received a BA in economics and political science, magna cum laude from Boston College in 1975, and received his Juris Doctor, which means his law degree, and that was from Santa Clara University, 1980. Bob has been very active in our community, speaking for our bars here in the area, and also we have an estate planning conference here locally that's very popular. It's called the Jerry Kasner Estate Planning Symposium. I go to it every year. Bob speaks there every year, so Bob, thanks for doing that.
Sure.
Does a great job. And anyways, contributed chapters to books, including the California Estate Planning book published by Continuing Education of the Bar. And he has also participated in writing our local rules of our court in Santa Clara County Probate Court. On a personal note, Bob is quite an athlete. He's an avid bicyclist. Last year, 2012, he tells me he went biking across the Pyrenees Mountains in France and Spain. So anyway.
Fabulous trip.
Yeah, sounds wonderful. He also plays hockey, so I mean, this guy is really tough. And he tells me they're going to make the finals in their league this year. And he also heliskis every year. So anyways, he really gets out there. Today, Bob and I are going to be talking about what I call I'm an executor, now what? So you may, in fact, be named as an executor in a will, and or named as an administrator or asked to be an administrator for a friend or family member. So we wanted to give you some information about what your duties might be, things to think about. In that note, though, we're only here for less than a half an hour, and Bob has spent many years studying this stuff and has many years of experience to share, and obviously can't do that in this short of a time. So we're just going to hit some highlights. But we hope that you'll find it valuable, and then that'll make the beginning of a conversation with your own lawyer. So, Bob, thanks again for joining me here today.
My pleasure, Mike.
Okay. Well, Bob, a lot of people have heard this thing, probate. Sounds intimidating. And, of course, whole books have been written about why you should avoid probate. What is it?
Mike, quite simply, probate is, it means to prove. It's a Latin word. Probare means to prove. The system of probate that we've developed here in California is a system that provides court supervision over a decedent's estate when an individual dies with a will or dies without any estate plan. We call that intestate, without any will or other estate plan in place. So it's probably the key words for probate are it's court supervised. Mm-hmm. We do not, unlike other jurisdictions, we have not adopted the Uniform Probate Code, so we don't really have an expedited probate procedure. If you're in probate, it's going to be court supervised from beginning to end.
Okay. Well, do all estates have to go through probate?
Indeed not. In fact, it's rare that an estate goes through probate in this day and age. That's due primarily to the fact that many clients plan to avoid probate. Mm-hmm. They do it with either titling, which is fairly common in modest estates or small estates, such things as joint tenancy or between a married couple, community property with right of survivorship, pay on death bank accounts. Mm-hmm. All of those are not subject to probate because they're contractually obligated or legally obligated to pass to either a designated beneficiary or their surviving owner. For more significant estates, most clients and individuals will use a trust to keep us out of probate. And the reason for that is the cost of probate, as well as the delays, are fairly significant. So planning to avoid a court-supervised process so that you can just meet with your legal counsel and your accountant and handle all of the forms that are necessary, but without getting a court's signature on it, is much more advantageous to many families.
Yeah, and to me, the big thing for trusts, we're going to have a whole separate program about trust, folks. But to me, privacy is like number one that comes out.
Well, the attorney-client relationship is private, and unlike probate, which is court-supervised, and anyone in the world can indeed discover who your heirs are, who your creditors are, what you owned, what it was worth, who it's going to, because it's a matter of public record in probate. In a trust administration, by contrast, it's private.
Yeah, I hate to say it, maybe it's a little joke, but anyway. It's a great way to shop for a spouse. You know, you go down to the courthouse and look at the postings up for the probate. So, oh, well, who's an interesting prospect here?
At least as to surviving spouses and available individuals, yeah, at least you'll know their net worth.
Right. Okay. Now, let's say a husband had a will. Excuse me, I'm skipping a question. So if they had a living trust, then we have somebody who's passed away now, they had a living trust. Does that mean absolutely that there's not going to be a probate?
That's a little more technical question, Mike, but the answer is if they had a living trust and if the assets that they owned were properly titled in the trustee's name of that trust, then the answer is yes, they would not have to go through any probate. But it's not uncommon that an individual will create a trust but fail to fully fund it, meaning they haven't transferred real estate or bank accounts or brokerage accounts into the trust name. We're fortunate here in Santa Clara County and in many Northern California counties, our courts are accustomed to entertaining kind of a one-stop petition to allow the assets that should have been in the trust to get transferred to the trust so as to avoid the entire probate process. But it's still going into court if you haven't properly funded the trust. So whenever a client does create a trust, it's key that the assets that they own, from the most valuable to the least valuable, get transferred to that trust.
Right. So just writing the trust isn't sufficient in itself. There's more work that needs to be done.
There's more work that needs to be done. At a minimum, there should be a general assignment of assets to the trust. There should be some sort of schedule of assets, but most importantly, the actual account should be titled. It'll make the job a whole lot easier on the surviving trustee.
Right. Okay. So now let's go back to the example. A husband had a will, he passes away, left all of his estate to his wife, and all of their property was community property. So is there a probate required in that scenario?
California law tries to make it easier on surviving spouses, whether they're surviving spouses that are registered domestic partners or unregistered if they're spouses in California. Now with the estate of Windsor and the unconstitutionality of the Defense of Marriage Act, they will make it easier on the survivor. In California, if your estate plan leaves it, if your will leaves it all to a surviving spouse, and it's all community property, no probate is required. A court petition is required to confirm that the survivor owns the decedent's half of the community assets, but that's a fairly routine, expedited proceeding.
Okay. So maybe just as a clarification, what is community property and why is that status important for estate administration?
Community property is actually defined in our family code. It is property that's acquired during the marriage as a result of one's time, labor, effort, and skill. Separate property, by contrast, is property that you either own prior to the marriage or that you inherited or acquired by gift during the marriage. Mm-hmm. So community property for most clients are the assets that you acquire as a result of your employment, your earnings, your labor.
Mm-hmm.
And that's defined as community. It belongs equally to both spouses, no matter who the wage earner is.
Right. So somebody that's been married forever, like me, for my wife and myself, really everything is ours, except for, like you said, she just inherited some property, so that's her separate property.
Correct. And
But,
let's
yeah.
keep in mind that even though a spouse might acquire separate property during the marriage, he or she's always permitted to convert it to community.
Right.
It does take a writing, it does take an express declaration, but there's nothing that prevents a spouse who has acquired separate property from converting it. The technical word is transmute, transmuting it to community property. Generally, I advise against transmutations for all the obvious reasons.
Right.
But that's not to say, particularly in a long-term marriage, that a transmutation would not be appropriate.
Yeah. So I've had some that I said, "You sure you want to do this?" And they said, "Yeah, we're sure." So, okay.
And it's something that we do very cautiously.
Yeah, with good reason. In fact, if you're dealing with a lot of property, I'm sure basically you're saying you each need to have your own lawyer.
Oh, yes. Anytime we're doing a transmutation, you want to have your individual lawyer advise you.
Right. Okay. So now some people, again, when they talk about probate, the thing that comes up is statutory probate fees. And so a lot of people maybe are rather terrorized or afraid about what those might be. Are they really that horrific? And can any other fees be charged by an attorney or by an executor?
The answer is, are they horrific? I suppose it depends upon the size of the estate and a number of factors. We do have statutory fees. What does that mean? It means that if a decedent's probate estate is at a certain level, a percentage is applied against that base fee, and that determines the amount of attorney's fees as well as the amount of the executor's commissions. Very briefly, it's 4% of the first $100,000 in the estate, 3% of the next $100,000, 2% of the next $800,000, 1% in excess of $1 million, and then it decreases after that. But on a $1 million gross estate, this is not net. So if you owned a house worth $1 million with an $800,000 mortgage, the gross estate is $1 million, and the fees on that are roughly $23,000. So it's not an insignificant amount of money, and that's paid both to the legal counsel for the executor as well as to the executor. So you double that, that's $46,000.
Right.
On top of that, you've got court filing fees, you've got probate referee fees, you've got hearing fees. Quite honestly, it wouldn't surprise me on a $1 million estate that total cost would be in and around $50,000. In addition, you're allowed compensation for what are referred to as extraordinary services. Those are probably best described as this particular issue's out of the ordinary in most probates. It might be litigation, it might be the sale of real estate, it might be the sale of a business or the liquidation of a business. Any number of activities undertaken by legal counsel in a probate could in fact be in the arena of extraordinary services, entitling one to ask the court for additional compensation.
So things can add up, and especially, I mean, folks, I'm sure we've all heard, when we get involved in litigation, it's like sky's the limit. So,
it's not cheap.
Yeah.
Looking for any alternative to litigation is generally going to be in everyone's best interest.
Right. What happens if the decedent died without a will?
That's called intestacy, and California, as all jurisdictions do, provide basically a will substitute. They will provide you with a will, and they'll tell you who your property is going to pass to. In California, intestacy says if you were married at the time of your death, community property will go 100% to the surviving spouse. If you're married with a child, the community will still go 100% to the surviving spouse, but any separate property will go 1/2 to the surviving spouse and 1/2 to the child. And if you have 2 children and you died at the time of your death, you were married, again, community will go 100% to the surviving spouse. Inherited or separate property will go 1/3 to the surviving spouse, and 2/3 to each of the children.
Okay.
Or 2/3 to the
1/3
two
each.
children.
So 1/3 total each. So okay. All right. How much cash should you keep on hand for incidental items at death? So, you can have things happen where funeral expenses and other things that need to be paid. What do you think that people should do in the way of having cash reserves?
For a married couple, most clients will have a small amount, at least in a bank account, to cover any urgent items. Most clients have credit cards. The expenses that are going to be incurred shortly after death are primarily going to be funeral-related expenses. And those can add up. Their funerals are not cheap. They're generally in the probably low side of $3,000 to $5,000, and high side, well, there's probably no limit on the high side.
Right.
But every mortuary takes credit cards. Every mortuary will certainly assist in making the economics viable. Many clients nowadays are buying pre-death burial arrangements and contracts through a mortuary, which can be very advantageous. But on average, I would say if you had $5,000 liquid in a bank, you're probably going to be fine, because I should be able to access the balance of the decedent's assets in a relatively short period of time in most cases. And if it's really urgent, the courts do allow what's called an ex parte petition to obtain letters of special administration to go in and get an administrator appointed for purposes of handling a business or obtaining cash or something like that.
Yeah. One item that can be a surprise that I learned about, and sadly with my own father's death, but anyway, when Social Security is paid and then the person dies during that month, then basically Social Security Administration says we want you to pay back that last month's payment, that can be a hardship for some people.
Well, that'll be reversed automatically. I mean, almost everybody nowadays has automatic deposits of Social Security into their account, and the minute the mortuary, and they notify Social Security Administration, that is automatically reversed out of the account unless you die on the last day of the month, in which case it's not.
Okay. So anyway, but it can be a surprise, and again, so since this is automatic, that means that you need to really watch what's happening in your bank account, because if it's, you had a couple $1,000s that went in and it's subtracted, you may have less in there than you thought.
Exactly.
Yeah. Let's talk a little bit again about some details here. What's an executor, what's an administrator, and what's the difference?
An executor is an individual or a corporation that is appointed under the decedent's will. So the decedent wrote a will, he nominated an individual, generally a family member, could be a friend, or a corporation such as a bank trust company, to serve as his or her personal representative. But that is a court-appointed person under a will. An administrator is still called a personal representative. They still are the legal representative of the decedent's estate, but this decedent died without a will. So when you have an administrator, you generally have an intestate situation.
Okay. What are letters testamentary and what are letters of administration?
I call them magic papers. In a probate administration, no one really has any legal authority to access any of the decedent's accounts until the court says you are officially appointed as the executor or the administrator. So letters testamentary are a court pleading that's certified by the court that says John Doe is appointed as the executor of the decedent's estate. And that's called letters testamentary. If the individual died intestate, meaning without a will, the court issues letters of administration. It's the same judicial council form, it's the same one page, it's the same certification, it's just a difference in title. And the banks and brokerage houses and third-party institutions will honor a certified copy of that court order or that court pleading.
Okay. Now, what's the significance of a death certificate?
Death certificates are obviously issued by the county in the state where the decedent resided. You're not going to be able to collect much of anything with respect to an institutional account without a death certificate, as well as without some sort of authority as to why you're entitled to represent the decedent's estate. So in some cases, there's some delays in issuing a death certificate because either cause of death is uncertain or there might be an autopsy. And so that can delay actually collecting on life insurance, death benefits, pension plan, things of that nature until the local authority issues the death certificate.
Right. So anyway, letters testamentary and letters of administration, those are focused on the thing like, again, you've got a probate that's going on. But death certificate is really much broader, so you use it together with your trust, or if you've got joint tenancy property, basically it's the proof that the person passed away, so now the title
Sure.
can be changed, all that stuff.
When assets pass outside of probate administration, a death certificate is going to be a key document, a certified copy, either to pass joint tenancy property to the surviving joint tenant, to file a claim for death benefits under a life insurance policy, or any sort of similar non-probate asset.
Right. So one thing to be aware of, folks, again, we've just said death certificates are used for a lot of things, and so one isn't going to be enough. And so you may need to count. Now, usually it's the mortuary, I believe, that helps you to get the initial
My
group.
experience is the mortuary will ask how many death certificates.
Yeah.
They're not cheap anymore. They used to be fairly cheap. They're
Yeah.
not cheap anymore. I don't know what the current cost is to get a certified copy, but it's I don't even want to speculate. My paralegal would know the answer.
Okay. There's some things that even
but the
the
bottom
attorneys
line
don't
is
know.
try to look at it from the point of view of how many different types of assets am I going to collect. That'll give you some indication as to whether or not I need a death certificate for
Yeah.
that asset.
So, I mean, one thing that I think of in the situation that I've dealt with quite a bit is, with mutual funds.
Sure.
And so each mutual fund, especially, you could wait for each one to say okay or whatever, but or let's say each family of funds, you're going to need a death certificate for that group. And if you're going to try to process them all at the same time, you need one for each one.
That's
And
correct.
so start counting and think about how many that you might need. And it's a kind of a tough time. You can get more later if you need them.
Absolutely.
Yeah. Okay, well, maybe you can talk a little bit about notice requirements that apply for probate estates, for creditors, beneficiaries, and so forth.
The probate process is all based upon notice to heirs and to beneficiaries. So when one dies with a will, California law requires that your petition to be appointed the executor is served on all legal heirs of the decedent, as well as all beneficiaries of the decedent's will. That notice has to go out, alerting the beneficiary and or heir that there'll be a hearing to have John Doe appointed as the executor, for example. So that's a notice that goes out just to get the ball rolling in a probate. Once the executor is appointed, the executor has a duty to give notice now to all known or reasonably ascertainable creditors of the estate. And so due diligence requires you to go through the decedent's papers, figure out what bills are owed, figure out should they be challenged or just paid. But notice has to be given to the creditors so that they can file a claim within the statutory period, generally 120 days.
Okay. And now also, isn't there like a published notice that happens in a newspaper and so on?
That's the notice of petition to administer the estate. So that is also published. That's the petition that is the one saying that the executor is going to be appointed. There'll be a court hearing on that date. And that it's also a notice that goes out to creditors to say if you are a creditor of this decedent, you also need to file a claim with the court as well as serve the personal representative.
And those are usually published like in a legal publication in the area? Or?
It has to be published in a newspaper of general circulation in the town that the decedent resided in.
Okay.
So if you, as an example, resided in the town of Los Gatos, you've got to publish in the Los Gatos Weekly Times.
Okay. Are there other notices that you need to be concerned about?
Both in probate and in non-probate situations, there are a number of entities that statutorily are entitled to notice. The California Department of Health Services is entitled to notice if you were receiving any sort of benefits, such as Medi-Cal benefits that the decedent may have been receiving. If you also have to give notice to the Victims' Compensation Fund if the decedent was convicted of any felony or even a misdemeanor, that there is some sort of remuneration that will be going back to the victims. That notice has to be given.
Wow.
So there are a number of statutory notices. Typically we'll file a Form 56, Notice of Fiduciary Relationship, with the Internal Revenue Service to let them know that the decedent's notices now should be going to John Doe.
Okay. Well, Bob, the time has flown. So as I said, folks, we can only hit some highlights from it, and even the highlights is hard to hit all of them in the time that we've got. But Bob, maybe you can throw out a final thought as we close up our little interview here.
Sure. Most clients think that death is going to only occur to friends around them. Most of us think we're somewhat immortal, but the fact of the matter is we're not, at least not that I'm aware of. And we do we tend to procrastinate our planning, and that really is a disaster for your family. Whether you're a single person, whether you're married, whether you're in a committed relationship, proper planning of your estate is really key. It doesn't have to always be sophisticated planning. It can be very simple planning. But give some thoughts on it. Consult with a qualified attorney, accountant, financial advisor, just to make sure that your estate is properly planned and it's reviewed periodically so that there won't be any unexpected surprises for your survivors.
Great. Bob, thanks again for joining me.
Pleasure, Mike.
And folks, I hope that we've given you some things to think about, but also I'll give you the caution again. This is just the beginning of a conversation. We haven't hit even all the highlights. So if you are in a situation that you've been named as an executor or asked to be an administrator, get help. Go and meet with an attorney and get that additional information. We'll see you next time on Financial Insider Weekly.